Good morning, everyone, and welcome to the September edition of DMH's Planning and Property webinar. Thank you very much for joining us this morning. For those of you that don't know me, my name's Emily Wood and I head up the Real Estate Disputes team here at DMH Stallard. For this morning, we have three topics to cover. If you could have the next slide, please. In terms of our contents for today, I will be speaking first on the Building Safety Bill, which is to introduce a new building safety regime. Then we have James Picknell, who will be repurposing the High Street as far as ground F redevelopment is concerned. And then Peter Rainier, who will be reinventing or discussing the reinvention of Crawley Town Centre. If you have any technical issues during the course of this webinar, then please use the chat function and our team will be able to help you with those issues. And in terms of questions on any of our topics, then we will cover those at the end of our seminar. So please use the Q&A function at the bottom of your screens to put in any questions. Hopefully we'll be all done and dusted in about an hour. So if we can begin, please. So as mentioned, I'm discussing the new building safety regime that the government has introduced via its Building Safety Bill. You really would have had to be living under a rock not to have noticed the public pressure that the government has been under to tackle the issues in terms of building safety following the Grenfell Tower fire. The failings include concerns over building regulations, the potential inadequacy of fire safety measures, and of course this resulting stalemate in those owners of high-rise flats being able to sell their properties. So the Building Safety Bill is an attempt by the government to tackle some of these issues. Some unfortunately may say that it fails. It was introduced into Parliament on the 5th of July 2021, and the government has described it as creating a lasting generational change and setting out a clear pathway for the future of how residential buildings should be constructed and maintained. So this morning, I'm going to take you through some of the provisions of the bill which affect really those occupying and owning residential buildings. There's this whole raft of other provisions relevant to the construction industry and to those designing and fitting out residential buildings. That's really beyond the scope of this talk today and indeed beyond the scope of my expertise. There's a whole other seminar to cover from our construction and planning lawyers. I wrap at the end of this talk considering some of the significant criticisms that the draft bill has faced and really raises questions of whether it does address what the government intended it to do. So in terms of the bill's proposals, well, the majority will apply to what is described as higher risk buildings. There will be much more stringent measures in place in relation to these type of buildings. And it covers both their design and construction and during their occupation. In relation to their occupation, which is what I'm going to cover, a higher risk building is defined as a building of at least 18 metres in height from ground level or at least 7 stories. It also must contain at least 2 residential units. However, the bill does provide provisions to vary the description of what a higher risk building is, so it might change over time. Now, what the bill really does is create a number of new roles in its effort to provide safer buildings. The first of those roles is the Building Safety Regulator, or the BSR. The role of the BSR, who will sit within the Health and Safety Executive, is really to enforce the more stringent regulatory regime for these higher risk buildings. Now, that role will include acting as the building control authority for work relating to higher risk buildings. It will advise on emerging risks and possible changes in building regulations. And it will be assisting and encouraging the competence of those that work in the built environment industry and any registered building inspectors. So a very wide role indeed. In order to help it with that role, the idea will be that it establishes 3 separate committees. The first is the Building Advisory Committee, which will look at, for example, building regulations. The second is the Committee on Industry Competence, which will be looking at the competence of professions working within the built environment industry. And the third, and most significant from my perspective, is that it will set up what's called a residents panel. Now, this panel will comprise of residents of higher risk buildings and relevant individuals who the BSR will have to consult with before issuing, for example, revised building regulations or any guidance relating to higher risk buildings. The idea is to ensure that residents who are directly affected by the new legislation will have a voice in the work that the BSR will be doing. How much account the BSR will take of that residents panel and the views that they have, we will have to see. The BSR will also be given certain enforcement powers under the new legislation. It will be able to, for example, issue compliance notices requiring any issue to do with building safety to be remedied by a certain date. It will also have the power to appoint a special measures manager who can be put in place to manage a particular building where there appears to be serious failures which are identified and could endanger the lives of residents. The second role that the bill envisages to create is what's called an accountable person. So for every higher risk building, there must be appointed an accountable person. That could be an individual, a corporation, or a corporate body. What we anticipate is that in very many cases, the accountable person will be either the landlord or the managing agent. That person will have to apply to the BSR for a building assessment certificate. So it will have to be, the BSR will have to be satisfied that the accountable person has been complying with its various duties under the new legislation in order for the building to be certified. The duties that the accountable person will have to demonstrate are that they've identified any building risks and they've assessed the building for those risks, and that they have taken all reasonable steps to prevent the occurrence and control the impact of any major incident resulting from those building safety risks. Now, the duties don't stop once the certificate has been obtained. The duties of the accountable person are ongoing, and they will need to demonstrate that they have this ongoing compliance by maintaining what's called a safety case record, which is essentially going to be a record demonstrating that the building is safe for occupation. The next role that the bill creates is the building safety manager. And we anticipate that this role is most likely to be filled by managing agents. The accountable person is to appoint a building safety manager, and it's to notify the BSR of their identity. Their principal role will be to support the accountable person in the kind of day-to-day management of fire and structural safety of the building. And they again can be an individual, an organisation, or a corporation, provided they possess the necessary competence, as it's described, to carry out that role. Now, we have very little detail as to what the criteria for being competent will be within that role. What we do know is that a Building Safety Alliance has already been launched, which will provide a certification scheme for building safety managers, and they will also hold a public register of those building safety managers that have been certified under that scheme. Next slide, please. But the bill doesn't only provide roles for, say, landlords and managing agents. It also imposes certain duties onto the shoulders of the residents of these higher risk buildings themselves. So a resident of a higher risk building, or indeed any owner of a residential unit within the higher risk building, will have certain duties, which include not to act in any way that creates a significant building safety risk materializing, or not to interfere with safety equipment that is within the building or its common parts. The accountable person will be able to enforce those duties on residents and, if necessary, go to court to get an order for them to comply. In terms of landlords and tenants under the new bill, there is also duties imposed on them. The bill will amend the Landlord and Tenant Act 1985, and it will require that landlords who are also acting as accountable persons, which is most likely the case, for their duties as an accountable person to be complied with. And they will also be required to cooperate with any person in connection with their building safety duties, such as the building safety manager. In terms of tenants' duties, next slide, please. They will have also implied duties, and these will be implied into leases, so they can be enforced by landlords. The tenants will have to allow the landlord, if they're acting as an accountable person, or the building safety manager, to enter into their flats for building safety purposes. They will also, where the tenant is a resident, have to comply with those higher risk building safety duties that are imposed on residents. And these, as I say, will be implied into the terms of leases. In terms of what is most perhaps controversial under the new bill is what is deemed the building safety charge. So this will be implied into certain leases known as relevant leases, and they are ones where the lease is at least 7 years and already has a service charge provision. What the landlord will be able to do in relation to those leases is it will be able to pass on to tenants the reasonable costs incurred by or on behalf of the accountable person in connection with their duties in relation to building safety measures. So these may include the costs of legal costs or professional fees in carrying out the duties of the accountable person. So instead of looking to the service charge provisions in a lease where these costs may or may not be covered, there will be implied into these relevant lease a mechanism for the landlord to recover these costs through this building safety charge. Next slide, please. Now, also very controversial and obviously been a lot in the news is the costs of remediating building safety defects, such as cladding in these higher risk buildings. So in terms of whether the costs can be passed on to the leaseholders, if the service charge provisions do cover these costs, then there is nothing in this new bill that prevents a landlord passing on the costs to its leaseholders. Now, this was really against the views of a lot of leaseholder bodies who wanted the insurance that these sort of costs wouldn't be passed on to the leaseholders. Well, that's certainly not in the bill as it presently stands. There is some limited protection for leaseholders, and what it does is provide that there are certain steps that a landlord must take before it passes on these sort of costs to its leaseholders under the service charge provisions. What it must do is take reasonable steps to ascertain whether, for example, there's any grants available that would cover the costs of remediation, or take reasonable steps to ascertain whether there is any third party who would be responsible or who the landlord could recover from the costs of remediation. There is also an obligation to take prescribed steps relating to any other kind of funding available to cover the costs. Other avenues that the landlord may be required to take that aren't yet in the bill, but we're expecting they may be, is to look to building insurances, indemnity policies, warranties, or claims against original developers and designers. Now, if the landlord does take reasonable steps and it's not able to recover the costs by these other methods, then there's, as I say, there's nothing in the Act that prevents a landlord putting these costs through the service charges, provided the provisions of the service charges cover these costs. Next slide, please. What you will also perhaps have seen in the news is that the bill intends to extend certain limitation periods so that landlords and tenants can look to pursue the original developer, for example, or contractors in relation to building safety issues. The bill extends two pieces of legislation. The first is the Defective Premises Act 1972. And very briefly, this act can create a duty on those who do works on a residential building to ensure that that work does not render a building unfit for human habitation. Now, ordinarily, claims under the Defective Premises Act are limited to the original construction or conversion of the building and not works that have been subsequently carried out to it. What the Building Safety Bill will do is extend that duty so that it does cover any works that are carried out on existing buildings, provided they're carried out during the course of business. It also extends the limitation period. So currently, any claim under the Defective Premises Act needs to be brought within 6 years. What the Building Safety Bill will do is extend that period to 15 years. And it will also have retrospective effect. So it might bring back to life claims that are currently statutory barred. In terms of the Building Safety 1984, the Building Act 1984, this act has a provision within it that was never actually brought into force, and the Building Safety Bill will do that. And what it will do will give individuals a right to claim damages where there has been a breach of building regulations, so very topical. It will also extend the limitation period again, so that claims will be able to be brought under the Building Act for 15 years rather than 6. Next slide, please. So when is all this going to come into effect? Well, we've got to get it through Parliament, and the government itself envisages that will take at least 9 months, if not longer. So we're likely to be into the spring next year before we have an act. And then it's going to be brought into effect in at least 2 phases. The first, the government says, will take about 12 months for things like the changes to the Defective Premises Act to come in, and the limitation periods to be extended, and the residents panel to be set up. Phase 2, which will be within 12 to 18 months from the Act becoming into force, and that will bring most of the other provisions into account, including this role of accountable person, the duties on residents. So we're still looking at over a year for everything to come in, and it could well take longer. It's got to get through Parliament, and there's obviously going to be some debate on it, particularly given the issues that Grenfell Tower showed. In terms of what the criticisms many have made of this bill as it's currently drafted, Well, probably the most significant is that it simply doesn't give protection to leaseholders against paying, footing the bill for work to remedy existing historic defects in building safety. It seems unlikely that the safeguards that it has added about the landlord having to take reasonable steps to look elsewhere first before putting costs through the service charge simply won't provide that protection. And indeed, the explanatory notes that accompanied the bill acknowledge that landlords can put these costs through service charges if these service charge provisions are wide enough. Other criticisms include the bill's definition of higher risk buildings, which is simply too narrow and won't cover a sufficient number of buildings where there are risks. There's also the costs of the new regime. Even on the government's own figures, they've assessed the costs at something like 3 billion to bring this new regime into effect. We've also got the widespread concern that the bill's changes to these limitation periods under the Defective Premises Act and the Buildings Act won't be wide enough. They won't cover a significant number of residents' claims who've been affected by historic defects. But also, there could be a whole raft and avalanche of claims against construction companies now that the limitation period, once the limitation period has been extended, which that industry simply can't deal with or satisfy. Perhaps the most widespread criticism is that just the length of time that all this is taking, that it's too slow to remedy the issues. Grenfell Tower occurred in June 2017, and we're still here waiting for an act to come into place. And we have a number of years yet to go. Obviously there's a call for much faster action. So that's my talk this morning. If I can now just pass over to James, who's going to cover repurposing the High Street and Ground F redevelopment.
Thanks, Emily. Good morning, everybody. So I'm here, as Emily says, to talk to you about redevelopment of the High Street in the context of Ground F, being the ground upon which a landlord can rely when seeking to oppose its tenant's right to a new lease under the 1954 Act. Now, we've long been known as a nation of shopkeepers, but as we all know, the High Street's been in decline in recent years due to the pressures brought upon it by the online shopping boom and business rates, and then in particular COVID-19 in the last 2 years, which has really accelerated the decline, the result of which means that a lot of units on certain high streets up and down the country are now left empty. But of course, some landlords still have their retail tenants and they'll be quite pleased about that, but there'll be some that might be looking to do something different. We've had quite a relaxation on the planning front in the recent years with the new Class E and PD rights, which enable residential development. It's a little bit easier to achieve that. And so some landlords will be thinking, well, what can I do to perhaps get a bit more money, a bit more of a return for my investment? And they may therefore be looking to get possession. Now, if you're a retail tenant and you're in possession with the 54 Act protected lease, it may be that you're not going to resist. There, of course, are other units available now on the High Street, which means that it might be a good time to get a new deal. But some tenants, and certainly I've acted for tenants in the past, are particularly keen to hang on to certain locations. They're key to their business, sometimes known as the crown jewels of their retail portfolio, and they will fight hard to retain those properties. So if you're a landlord and you're in a situation where you're looking to develop and you've got one of these tenants, what are the sorts of things you might need to be thinking about? Well, the first point to briefly touch upon is restrictive covenants. It may be that the title to your property, the freehold that is, or perhaps a long lease, contains a restriction on user, meaning that you can't simply change from retail use perhaps to residential. And so that's an issue which will clearly have to be tackled. It's not a topic for discussion today because it's a large discussion point and perhaps one for another seminar. As I say, what we're here to talk about is Ground F, the Landlord and Tenant Act 1954 being the redevelopment ground. And that's really what you as a landlord are going to have to think about if you're looking to redevelop premises where you've got a protected tenant. Next slide, please. I'd like to have gone into a bit of detail today about the 54 Act and just to cover some of the basics, but we don't have time for that, and also have to sort of rattle through ground F as it is. But let's start then with ground F. It's probably the most popular of the grounds of opposition available to a landlord. There are 7 in total, and it's the one that crops up the most. As it says on the screen, those are the words of ground F, that on the termination of the current tenancy, the landlord intends to demolish or reconstruct the premises comprised in the holding, or a substantial part of those premises, or to carry out substantial work of construction on the holding, or part thereof, and that he could not reasonably do so without obtaining possession of the holding. So that's what you've got to deal with if you're a landlord. That's what you've got to overcome. Can it really be that complicated? In some cases it isn't, but there are many cases where it can be. Can be quite a testing section to overcome. And indeed, there have been many cases that have picked apart the various different components of ground F over the years, meaning that you need to look at it properly and carefully before rushing in. And we'll spend a bit of time looking at that. So what do I mean by the ambitious and impatient developer and the tactical tenant? Well, if you're an owner of a property and you've seen a development opportunity, then you'll be keen to get on with it and make the money and move on. And it's quite tempting in that situation for a property owner to want to just rush in and serve the Section 25 notice on the tenant, relying upon ground F just to get the ball rolling and the process underway. But it is important, if you've got the benefit of time, the luxury of time, just to take that time and think about your case with your advisors in detail before rushing in. Now, the reason for that is because of the tactical tenant, as I'm calling them here. If you're a well-advised tenant who's keen to hang on to its property, then upon receipt of such a notice, the first thing you'll do is ask the landlord to provide the evidence upon which it's relying in support of its ground F claim. And if you as a landlord have rushed in and you're not ready to support that claim, you can be quickly found out. And if the tenant wants to, it could put you under some pressure by immediately issuing proceedings and then seeking a fast court timetable through to trial, thereby giving you less time to get your house in order. So that's a tactical point to be aware of. And in fact, there's lots of tactics involved in the 54 Act, and in particular ground F. So that's just one point to take into account. Next slide, please. So dissecting ground F, without getting too technical, let's just have a look at some of the parts and what it actually means. If you're that landlord looking to redevelop your property, then you've got to show that on the termination of the tenancy that you are ready to do your ground F works. So what does the termination of the current tenancy mean? Well, to start with, it will be the date in either the Section 25 or the Section 26 notice. But in practice, if the matter is litigated, then the termination of the tenancy will generally arise 3 months after the disposal of the proceedings, i.e. 3 months after the trial. There is, however, a bit of a cushion on that, in that there has been case law where the courts have allowed a reasonable period of time beyond that, and in one case 3 months was allowed. Just an interesting point to note here, in the context of these new PD rights for residential change of use, that does in fact require a prior approval application to be made to the local authority. And one of the conditions of that is that you have to have shown that the property has been vacant for 3 months, which of course won't be the case with ground F, because you'll be rocking up at trial with your tenant on the other side, and they'll still be in occupation of the property. So it'd be interesting to see how ground F claims in the context of PD rights and residential use come into play, and how they're looked at by the courts, and whether the court will allow a bit of time for that prior approval application to go through, if in fact it's supported by expert evidence to show that it's going to be rubber stamped. So next point then is you've got to, sorry, not next slide, beg your pardon. Next point, you've got to show a genuine intention as the landlord to do these ground F works, and you've got to convince the court of that. It's got to be a firm and settled intention, but you don't actually have to prove it until you get to trial. That's long been the case pursuant to the case law. However, if you, of course, you can't prove your intention earlier when put under pressure by your tenant, then it will potentially expose a weakness, and the tenant will start to look at why it is you can't prove it and what you've got left to do in order to prove it. Which then comes on to the question of evidence. Get your ducks in a row is the important point here. If you've got the benefit of time, sort out your evidence so that when your tenant asks for it, you can hand it over and hopefully bring the matter to a close without a proper fight. In terms of the evidence that you need to prepare, some examples would be board minutes if you're a corporate, approving the decision of the company to actually go ahead with this particular development. You will need to be able to show that you've got the relevant planning permission if in fact one's needed. And if you haven't got that permission, when the 54 Act process is underway, then you'll need to be able to show reasonable prospects of obtaining it and prove to the court there's a real chance that you will have that permission in place from the local authority, and of course have it in time in order to carry out the works on the termination of the tenancy, not in sort of 2 years' time. The other thing to think about is how you're going to finance this particular project. You need to be able to produce evidence to show that you are in a position to pay for it. So that's also important. So there are other pieces of evidence as well that we would need to consider with you if you were thinking about a ground F claim. So those are just a few examples. Now, the question of motive is an interesting one. Does it matter as to why it is that the landlord wants to do these ground F works? Motive is irrelevant, generally speaking, unless it affects the landlord's intention. And this point actually came up in the Supreme Court a couple of years ago, where a landlord had devised a scheme of works which had no other commercial purpose really other than just to get the tenant out of the property by satisfying ground F. And unfortunately for the landlord in that particular case, it was found on evidence that the landlord wouldn't have undertaken those works if the tenant had left voluntarily. And so the court considered that this really affected the quality of the landlord's intention. It wasn't strong enough, it wasn't a genuine intention to do the works come what may. And as a result, the landlord failed. So the question of intention is very important. And when it involves questions about motive, these difficult issues need to be looked at. The final point on this slide is that you've got to show that you could not reasonably do these works without obtaining possession of the holding. Now, this doesn't just mean physical possession. Case law shows it means legal possession. So you need a lawful right to be able to do these works. And what that really points towards is, what does the lease actually say? Because often leases will reserve rights of entry for landlords to come onto the premises and carry out certain works of improvement, or in some cases development. They tend to vary in their parameters, but it's important to look at that at an early stage. Otherwise, you might find yourself in a situation where the tenant points to the particular clause and says, well, hang on a minute, a lot of the works that you're looking to do here don't fall within ground F because you can already do them. And the court will separate those works out from those you can do without getting possession and those you can't. So that's an important point to look at. Next slide, please. So just moving on then, quickly then to the question of works. What specific works is it that the landlord needs to do? Well, broadly speaking, it's show an intention to carry out works of demolition, reconstruction, or construction. Those words have each, as you can probably imagine, got particular meanings that have been given to them by various judgments over the years. We don't really have time today to go into that. The point to take away, I suppose, is that you need to undertake at an early stage a careful analysis of precisely what work it is that your client is looking to do. I mean, if they're looking to demolish the entire building, then it's a fairly short discussion. But if what they're looking to do is less than that and only affects parts of the premises, that's when a careful analysis of the scheme of works needs to be undertaken, so that you can be satisfied at an early stage that ground F will be made out, or else money could end up being wasted on instructing architects and planning consultants, etc., to prepare the scheme for when in fact the scheme's not going to get off the ground. The eggshell demise. What do I mean by this, and is it capable of being demolished? Well, the eggshell demise is quite relevant really in the context of the high street, because most retailers, or lots of them, will have leases of the internal parts of the premises only, and will only be demised, for example, the plaster surface, floor surfaces and ceilings of the property, and there'll be no aspect of the structural or other parts of the premises which basically hold the building up. Those bits will be outside of the demise. And this came up in court a number of years ago, and the question was, well, can you, as a landlord, satisfy ground air by stating that you intend to demolish the premises when in fact the premises consists of the plastered surfaces, etc. And the court said, yes, you can. So that's an interesting point just to be aware of when dealing with retail leases. So a couple of very quick examples then of shop cases where landlords have come up against the courts on whether or not they can satisfy ground air. And these are cases really that concern the scheme of works affecting parts of the property as opposed to complete demolition. It was found in these two cases that the landlord would succeed. An example of one is that there was an amalgamation of two shops into one by removing 3/4 of the dividing wall. Alterations were undertaken to pillars which were supporting the ceiling, and then an installation of a new double fronted shop. Another case involved the demolition of walls bounding two shops to create a larger unit, the demolition and replacement of the shop fronts, and the removal of lavatories and the installation of a staircase. And taken together, these schemes of works were all considered by the court to be satisfactory to get home for the landlord to get home on ground F and succeed. So the final point, just briefly on this slide, then, is the fine line between success and failure. With all of these cases, they are fact-interview cases, and they depend, on the terms of the lease, but in particular on the type of work the landlord is looking to do. And you won't necessarily get the same response from a judge in answer to one scheme of works as you would from another judge. And that point, in fact, was highlighted a number of years ago, where there are a couple of cases that came to court in quick succession to each other, but they were separate cases, although they really ought to have been tried together. But they involved two hotels side by side. And just briefly speaking, what happened is one landlord succeeded with ground up and one landlord failed, notwithstanding the fact that the scheme of works for both of the hotels was very, very similar. And there were reasons, obviously, for the decisions that were reached, but ultimately the judge felt that they couldn't interfere with one of the judge's decisions on appeal, because the judge hadn't misdirected himself, and it was within the sort of the realms, the parameters of his jurisdiction to make that decision in that particular case. So there can, in some cases, be a fine line, which again just highlights the point. It's very important to assess the merits of your case at an early stage before rushing in, if indeed you have that time luxury. Next slide, please. The final point just to talk to you about then is the tenant's right to compensation. If you're a landlord and you serve a Section 25 notice or a counter notice to a Section 26, relying upon ground F alone, then you are likely to have to pay compensation to your tenant if that tenant leaves, or if you end up succeeding with your case and the tenant isn't granted a new lease. Compensation is, in most cases, will be 1 times the rateable value of the holding, and the valuation date is, generally speaking, considered to be the date of the Section 25 notices and Section 26. So you look at the valuation list as at that date to ascertain the rateable value. However, there can be cases where double compensation is due. If, for example, you're a tenant who's been in occupation business purposes for 14 years or more, then you're entitled to double compensation. Or if, in fact, you've purchased a business of somebody else, and you continue that business, then your period of occupation can be added together with the period of occupation of the previous owner. And if you get to 14 years or more, then you're in double compensation. Tactics, then, just the final point to cover. If you're a landlord, then one way of potentially avoiding compensation is to rely upon a non-compensation ground of opposition, such as one of the fault grounds or perhaps suitable alternative accommodation. If you're able to succeed with one of those grounds, then the tenant won't get their compensation. And so it's tempting sometimes for landlords to look to throw in one or more of the other grounds to try to get out of the responsibility of paying compensation to their tenant. Obviously, the risk with that is, of course, if your case is poor and you're going to be found out, then you may be liable to the tenant on costs if you hang on to that argument too long. From a tenant's point of view, when it comes to tactics and compensation, I would say in my experience that the majority of ground F cases when acting for tenants tend to revolve around trying to get the tenant a better deal on compensation and perhaps buy as much time as possible to find another property to relocate to. Often that tends to be the more cost-effective and commercial approach to be taken when dealing with the ground F claim, as opposed to fighting it tooth and nail all the way to the court door. And so the tenant will be looking to create some leverage by attacking the ground F claim, perhaps looking to go for a slower pace so as to frustrate the landlord's plans to get possession. The landlord will be dead keen to get possession as quickly as it can in most cases. And so if you can slow them up, that will frustrate them and might bring them to the table to agree to negotiate a better compensation package. Right, that was a bit of a rattle through on ground F. Obviously happy to take questions. I'm now going to pass over to Peter, who's going to talk to you about reinvention of Crawley Town Centre. Thanks.
Thank you, James. Yes, I'm Peter Rainier. I head up the planning team at DMH Stellhard. I'm a town planner rather than a lawyer. So, and I'm just going to canter through very quickly in 10 minutes or so what's been happening recently in Crawley. Hopefully it's a town that we all know well. Many of us are based there in terms of our work life. And so I'm going to cover the planning background initially, then look at what support there has been for Crawley Town Centre and what's happening, and then look at a couple of schemes that are on the ground and what's happening in terms of those. So I can jump that slide, thank you, and go to the next one. So Crawley Town Centre, as I said, probably known to most of you. It's a new town, and with most new towns, probably all new towns, it started off on a very plan-led system of having neighbourhoods outside of the centre of town for residential, and then small little groups of shops in those neighbourhoods. And then the town centre itself was really a commercial and main retail hub, but it didn't really have any residential accommodation actually in the town centre. It's relatively low-rise buildings, those in this picture to the right. This is Queen Square, which has been recently revamped and improved. We've got fountains and planters and increased trees, etc. in there now, which has improved matters quite a lot. But in terms of the buildings, those on the right are probably typical of the town centre, 3-4 stories at most, fairly low rise, with some sort of commercial space above, retail at ground floor. Next slide, please. So this is just a quote. This is a quote actually from the emerging local plan, and I thought it was interesting, just the end of it, really, just to give you a flavour for what's been happening in Crawley. The residential number of units within Crawley Town Centre in 2014 was actually 240. And there are now over 1,000 dwellings in the town centre over that period, just in the period of 7 or 8 years, and then a residential population of around just over 1,000 people, and anticipated going forward over to 2037, which is the next local plan period, to increase by a further just over 2,000 to bring an overall residential population of around 3,000 units within the town centre, which is very significant change. But obviously it's the most sustainable part of the town, next to rail and road infrastructure. And therefore, in planning terms, it's absolutely where we should be building, and is helping for development not to carry on greenfield sites on the edge, albeit that is having to happen as well, but it's limiting that. Next slide, please. This was the town centre supplementary planning document back in 2016. And I just put that slide up really just to show you that the Those red and brown areas, hatched brown areas, those are the areas that the council thought at the time would be potentially developed, and virtually all of them have been or have planning permission. So the red, almost all of the red areas have been developed already. The one on the very south of the red area, south of the bottom of the page, has got permission but is yet to be implemented. And the brown areas, those to the north, the main area to the north has been developed, which we'll come on to later. The county buildings in the northeast are up for redevelopment, and those to the south have, one has got permission and one is sort of pending, and so it just gives you a flavour for how just in that short period of time those sites have come forward, leading to that increase in residential number of units in the city centre, in the town centre. Thank you. Next slide. Yep, so this is the future local plan, looking to enhance the nighttime economy, looking to help continue there to be a good retail environment, but to give flexibility, to try to make use of those upper floors that we saw in that initial picture, and also to make efficient use of town centre sites sustainably to drive up those residential densities. Next slide, please. There is a proposal for a possible conservation area, which might raise some eyebrows in Crawley town centre. There's already one at the High Street, but there's one proposed. If we jump to the next slide, actually, and I can just talk through the previous slide with that one showing. So this is the Queen Square area in the middle, and that's shown on the initial picture. So it's indicating that the council are considering a conservation area in the centre of town, and quite a lot of representations, perhaps not surprisingly, have been made about that because of the conflict between trying to conserve what is deemed to be perhaps a typical new town centre versus the architecture of it, which some would say is not of great merit. Others might disagree, but trying to do that whilst also trying to drive up those residential densities and trying to make best use of the site and trying to give flexibility to uses. So it'll be an interesting to see how that one goes. That's been out to consultation. Representations have been lodged by a number of parties, and the council are considering those, and I suspect a decision will be made sometime probably in the new year. Next slide. We've also touched upon already Class E and PD changes, so that obviously gives the right to change from Class E to residential, and the government is hoping that will support housing delivery, but there is concern that that could have a detrimental impact on the town centre, and lead to impacts that are not really foreseen by the government. And a more disparate retail function of the town centre. So again, the council will be considering whether or not it should be imposing an Article 4 direction and things like that over some of the town centre to try to protect town centre uses. Next slide, please. So yeah, I'll just touch on funding and support. There's been a huge amount actually of funding and support for Crawley Town Centre. There's a Crawley Town Centre growth programme and a growth deal, which deals not only with the town centre but also with the Manor Royal commercial area to the north of the town centre, between Gatwick and the town centre, for those that don't know Crawley well. But the whole purpose of this programme really is to get a critical mass of public and private funding aligned, so to maximise growth benefits. So that will make, well, there's about up £60 million worth of investment going into Crawley Town Centre, or Crawley generally, and part of that to the town centre to assist with funding improvements to road and the railway station, and just the public realm in between the station and the town centre, etc. So that will bring about or help with the development of the town centre in terms of the number of houses to be built, but also hopefully to grow new retail investment. Thank you. Next slide. Yep, so the Town Deal Board has had confirmed from government that it can progress with up to 10 projects and receive money from the Towns Fund over the next 5 years. And that new Crawley Town Deal Board is established, and over 50 representatives of local businesses and community and public organisations are on that board, and probably many of you here are perhaps well aware of that and perhaps on that board. Next slide, please. There's also now a Crawley Town Centre Business Improvement District, which I do sit on, and that Business Improvement District is also helping to take a levy from those levy payers in the town centre, and there was a vote on that which was supported, but that gets around £2.5 million worth of levy income over 5 years, again to try and capitalise on the new housing and to bring physical changes, improvements to the environment within the town centre to enhance it and to make it more attractive. Next slide. So what's happening on the ground? Well, I could actually have picked a whole, there are, as we showed on the original, on one of the earlier slides with the red and the brown areas, there's all of those sites are up and running or coming to fruition through planning. So there's probably 10 sites there that could have been picked, but I picked a couple. This one because I was involved in the planning. So this one is Crawley Town Hall and the neighbouring 2 sites. So this is what's going to be known as the Create space. And I think there's some people from Styles on the call, and they're acting as agents for this, the renting of this building. BREEAM excellent building, and hoping to be completed in Q1 of 2022. And will provide Crawley Town Centre with its first Grade A office building for 7 years. That was on the site of the Old Town Hall. The existing council offices are immediately to the east of this building, and they're still being occupied. When this building is finished, Crawley offices will move into the lower couple of floors of this building, and that will enable the existing office building at Crawley Council to be redeveloped, and planning permission exists there for around 180 units immediately to the east. And then next slide. And then the site that's immediately east of that was a former low-rise car park, just a couple of story, multi-story car park, but only a couple of stories. And that has been developed now, and that's a photograph of it. It's taken a couple of weeks ago. It's now almost complete and contains a further 90 units. And these schemes are sort of circa 10 stories high, both this and the Crawley Town Centre one we showed previously. So that's showing how really they're increasing height and increasing density just on the edge of the town centre. I think that both those schemes will be very successful. And then next slide. And then this is one that has been a long time in planning, not one I dealt with directly, but Overline House in the Crawley Station area. Has been granted a couple of different planning consents, but most recently, earlier this year, was granted permission for the upgrading and conversion of Overline House and a couple of additional floors on top to provide 83 flats with those additional 2 floors, and then blocks going off further to the east. And that is helping to unlock the £7 million worth of public funding towards improvements to the public realm and the station area. Thank you. Next slide. And so that's a canter through the planning situation in Crawley and what's happening. And yeah, over to you for any questions you might have.
Thanks, Peter and James, very much indeed. So yes, we've had a couple of questions in on the Q&A. So I think this one's for James. Yeah. So do you think we might see more ground F applications and claims in the retail sector in particular?
Yeah, I think possibly. given the relaxation in the use classes, in the government's keen to sort of inject a bit of life into the high street, it means it gives the landlords, owners of these properties, more options to look at, and perhaps in some cases might make it a bit easier to satisfy ground F in terms of not having to go up and get a planning permission if you've already got the right to change use. So yeah, quite possibly.
Okay. And a question for me, does the building safety bill define what a building safety risk is? Obviously that's a term that I used throughout the talk. So in answer to that, yes, it does, although it's incredibly wide and can be extended. So what it says is that a building safety risk is a risk to the safety of persons in or about buildings, resulting from the occurrence of fire spread, which you would expect, and structural failures, and any other risk that may be prescribed by regulations in the future. So we don't have a definite definition. It could cover far more than fire spread and structural failure. We'll have to see what the government brings in terms of regulations to sit alongside the Act. I'm very conscious of time. Just one further question for Peter then, if I may. Peter, with the additional residential units, what is the plan for additional infrastructure of schooling, doctors, surgeries, etc.? There's already an overload on existing services with the outer developments of Crawley, says one of our members of the audience.
Yeah, hi. I think it was Trevor, wasn't it, that made that point. So it's always a question, always a difficult question, to be honest, with planning generally. But what does happen here is that Crawley have what's called CIL, Community Infrastructure Levy. So for every house, they have to pay an additional tax, really, and that goes towards infrastructure. Not only we've talked about the funding of improvements to cycleways and roads and rail in the town centre, but it will also go towards schooling, to go towards county council functions, schooling, policing and the like. So they will be looking at, the Education Authority will be looking at what that additional population has to, what pressure that puts on schools in the local area, and looking to expand those as necessary to provide the additional spaces that are needed, and the funding will help to come from the additional housing that's provided. With doctor surgeries, it's even more difficult, but that really just comes from the doctors themselves, and the health authority look at those needs, and again will provide additional facilities, and the council indeed will look at providing additional facilities within the town centre, surgeries and the like, but it does need to be undertaken with the health providers to make sure that there is joined up thinking, but they're very much a part of the planning process, the health authority and education authority.
Okay, thank you. So as I say, conscious of time, so we'll draw it to a close now. Thank you very much for joining us this morning. Our next will be in November, so very much hope you can join us then. Invites will come out nearer the time. As always, if there is a topic that you would like us to cover, we would be grateful for your feedback and happy to then do so. So always email either myself or one of the team. Our details are up on your screens now. And yes, thank you again and enjoy the rest of the day. Goodbye.